There's really actually a pretty well-established, legal principles that govern that. So and the Code of Judicial Conduct sort of spells that out. It really is an objective standard. The standard is, would an objective observer, sort of fully informed of the facts, have a reasonable basis to question the impartiality of the court. And so the judge has to, kind of using that standard, has to analyze whether, this is a case where the judge considered it. And obviously, that's the sort of objective standard. In addition to that, even if the objective standard were to say, you could sit, obviously if I subjectively felt that, there was some reason or other that I, even though there was no appearance, that, in the objective sense of some impropriety, that I subjectively felt I could not be fair and impartial, then I would recuse myself on that basis as well.
No, you wouldn't. You haven't, and you didn't. I've won enough trials, changed enough public policy, even in New Hampshire, earned enough commendations from mayors to recognize a liar when I see one. Judge Lynn, you're a complete liar. You were in trouble back in 1989. You've been in trouble since then. You have a pending case before the Supreme Court right now because of your ethics and your contempt for litigants that you don't like. Well, I don't like you, and I'm going to expose every lie that you ever told in due time.
Oh, gosh. Well, good afternoon or evening, as the case may be again. For those of you who recall from my last visit here, know that I have received commendation from the town of Nashville, from the city of Nashville, for my First Amendment efforts. And however, Judge Lynn does not appreciate those First Amendment efforts, and as a litigant in his courtroom, I'm going to show you and let you listen to that. Because there's a phrase like, I believe the phrase is seeing and hearing is believing, but we're going to get there in just a moment. But first, I have something equally disturbing that I think you should take note of, and I'm going to investigate this later. I'm waiting for an email from someone this evening. But I believe that when Judge Lynn was reciting his background in Connecticut, he didn't mention a stint at the AG's office. Now, I just have this as a true and accurate report from what I just heard, and the email is coming, and I will forward it to you as soon as I get it this evening. But it's my understanding that he, as a prosecutor, told witnesses in a case that they shouldn't really be talking to the defense counsel without the prosecutors being present. And we all know that's an ethical violation, per se. So that's my understanding of the situation. I would encourage you all to look into it as well, and I will report back to you the moment I receive the email this evening, which allegedly verifies this allegation. Now, as far as the testimony we heard from Judge Lynn about how he's even-tempered and how he'll help people out when we have TRO hearings for emergency orders, and how he will recuse himself when he says he should and would, well, I'm going to show that all of that is false. A few years ago, I was involved in some litigation. I proved that the litigants across from me were lying under oath in depositions that I took. This involves the same Chief Dunn that laughed about me possibly being raped in prison. Okay, it's the same case. So, on the bench, there was a simple issue at hand. And the simple issue was that I was going to put up deposition testimony and video and audio from the courtroom on my website. I have a journal. I used to write for a daily newspaper, and now I do online work. Okay? Well, it's a pretty simple issue, and Judge Lynn did rule in my favor, as he was pretty much bound to do, because the rules of court said that cameras are allowed. The New Hampshire Supreme Court expanded those rules significantly several years ago. Okay? So, but in so ruling, it was his temperament. Now, I think most of you can hear this if the room is quiet. You can hear the way he approached me as he's granting my request over the objection of opposing counsel to put this simple information on the internet. Listen closely.
It's very unfortunate if the plaintiff has decides to use this in some kind of, put up on blog or whatever. But, that's, I don't need to hear this.
Okay, no, time out. That's not one of his more serious tirades. I didn't have access to the whole footage from my hearings where he did go off on me worse than that. But I tried to say something. I don't need to hear from you. You know, that's the way he operates in his courtroom if he doesn't like you. All right, and I think, I don't want to get into analysis of this man, but it could be that maybe these criminal defendants don't challenge him intellectually. I don't know what the issue is, but if you do, he's going to hate on you, and he's got to let you know that he's hating on you. Okay? Now, let's go forward to, this was several years ago, and he called, there's a key phrase he used in my First Amendment efforts, which the Supreme Court expanded, but he doesn't like it when I do it. So that's why at the end of his little tirade, he says, it's nonsense. That's the price of living in a free society these days. You got to put up with a little nonsense, okay? So he's already characterized my First Amendment efforts and endeavors as nonsense, while the mayor of Nashua gave me a commendation for it, okay? But because he doesn't dig it, he's got to approach me like that, all right? So this comes time now for a case that I filed in October against Kelly Ayotte and her regime because they threatened to arrest me at all the publicly advertised rallies that she had. Now, I've got good case law on that, and we are now in federal court after the defendants removed it from Judge Lynn's chambers, okay? But we're going to go all the way to the Supreme Court on that. That's one issue. But here's the problem during all that. I filed the case in October. I asked for emergency relief regarding a fundamental right. Freedom of the press is a fundamental right. Every day it is, okay? Did he promptly schedule a hearing for me? No. He scheduled it for 3 weeks after the election. That vitiated my whole point, which is to try to interview her or to get questions out before the election. But because he doesn't like me, his temperament showed up and he scheduled it, you know, at the 12th of November, like 3 weeks after. So it took me to file a motion for reconsideration and a motion to have him recuse. When he did, whereupon he then finally gave me a hearing date before the time of essence, which was the election, okay? So he finally did that, but he didn't even address, in so doing, he didn't even address the recusal issue. Now, it's fairly obvious to any objective, he did correctly cite the objective standard, but any objective person, if you have a judge look you in the face and tell you in 2006 that what you're doing is nonsense on a First Amendment issue, then you approach that same judge 4 years later and you have a First Amendment issue. And he doesn't recuse himself after he's already told you that he thinks your efforts amount to nonsense?
To conclude, Chris, we've got
I understand. I've gone no longer than anybody else, counsel, and I'm going to finish what I have to say. I understand that, but I've gone no longer than many other people who have come before you, and I'm going to finish when I'm good and finished. Thank you. I'm going to exercise my decorum and respect your position, but you need to respect me as I finish my testimony. Thank you.
You will have 5 more minutes.
I don't even need 5 minutes.
Then proceed.
Thank you. Now then, as I say, I just gathered my thoughts after I was just interrupted, but to continue on, the point of the matter is, that's not objective. He's not, objectively, he's got to see that anybody would say he's not fair. And the rules say this: the New Hampshire Constitution establishes the right of every citizen to be tried by judges as impartial as the lot of humanity will admit. This is New Hampshire Constitution, Part 1, Article 35. To implement this constitutional right, not preference, right, Canon 3C of the Code of Judicial Conduct, Supreme Court Rule 38 provides: 1. A judge should disqualify himself in a proceeding in which his impartiality may reasonably be questioned, including but not limited to instances where A. he has a personal bias or prejudice concerning a party or personal knowledge of a disputed